10. Discharge of contract. A contract is said to be discharged when all the parties to a contract either perform or extinguish their respective obligations under the contract. A contract may be discharged in any of the following ways. First, by performance. Second, by mutual consent. Third, by lapse of time. Fourth, by operation of law. Fifth, by impossibility of performance. Sixth, by breach of contract. First, discharge by performance. There are two ways. First, actual performance. Second, attempted performance or offer to perform. Second, discharge by mutual consent. Such discharge may be by novation, rescission, alteration, remission, waiver, or merger. Section 62 and 63 of the Act provide for various modes of discharge of an existing contract by a fresh agreement between the parties with their mutual consent. They are: first, novation. Novation means substitution of a new contract in place of an existing one with the consent of all the parties to the contract. The existing contract stands discharged when a new contract emerges. A novation of contract may be of two ways. First, contract with new terms between the same parties. Second, alteration. Alteration means altering or changing one or more terms of a contract with the consent of all parties. When altered terms comes into effect, it discharges the original contract. Third, rescission. Rescission of a contract means cancellation of a contract by the consent of A, all the parties to it, or B, by the aggrieved party to it. A party may resign the entire contract. Note: rescission of a contract in part is not possible. Fourth, remission. Section 63 allows remission of a contract. Remission means acceptance of a lesser performance in discharge of a whole obligation under a contract. Fifth, waiver. When a party entitled to claim performance releases the other party from his obligation to perform it, it is called waiver. Sixth, merger. Merger means merging of inferior contract into one superior contract. When an existing inferior right of a party merges into a newly obtained superior right by the same party, it is a merger of rights. In such a case, the inferior contract automatically stands discharged. Third, discharge by lapse of time. A contract may be discharged by lapse of time. When a contract is to be performed within a stipulated time period and a party does not perform it within that time, the contract is discharged by lapse of time allotted for its performance. Fourth, discharge by operation of law. A contract is discharged by operation of law in the following cases. First, death. In case where the contract requires personal skill of the promisor. Second, insolvency. When a person is adjudged insolvent by the competent court. Third, material alteration. Material alteration means a change or alteration in the rights and obligation of the parties in a significant manner. Fourth, merger of rights. Sometimes inferior right of a person merges into a superior right of the same person under the same or other contract. Fifth, discharge by impossibility of performance. As per section 56, an agreement to do an act impossible in itself is void. A contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent becomes void when the act becomes impossible or unlawful. There are two kinds of impossibility. First, initial impossibility. Any agreement to do an existing impossible act is void. Second, subsequent or supervening impossibility. Subsequent impossibility is one which arises after the formation of a contract. Such impossibility arises by the reason of some event beyond the control of the promisor. In such a case, the contract becomes void when the act becomes impossible or unlawful. If following conditions are satisfied, the contract becomes void. First, the impossibility of performance emerged after the formation of the contract. Second, the impossibility should be due to event or circumstances beyond the control of the promisor. Third, the impossibility should not result due to some act or negligence of the promisor. Note, the concept of supervening impossibility is known as doctrine of frustration in English law. In the following cases, the supervening impossibility, that is, frustration, may arise. First, destruction of subject matter for which the contract is formed. Second, failure of ultimate purpose for which contract was entered into. Third, death or personal incapacity of the promisor. Fourth, change of law of enforcement of powers by the statutory authority. Fifth, outbreak of war. Sixth, order of the court. In the following exceptional cases, the concept of supervening impossibility does not apply. A. Difficulty in performance. B. Commercial impossibility. C. Failure of third party. D. Uncontrolled events like strikes, lockouts, etc. E. Impossibility of one of the object. Effect of frustration or supervening impossibility. First, contract becomes void. Second, aggrieved party can claim compensation for loss if the impossibility of the act was known to the other party, still it enters into the contract. Third, both the parties should restore or compensate benefits received during the contract. Sixth, discharge by breach of contract. Breach of contract means refusal or failure of one party to perform his contractual obligations under the contract. Breach of contract may occur in two ways. First, actual breach of contract. Failure by one party to perform on the due date of performance or during the performance is known as actual breach of contract. Second, anticipatory breach of contract. Anticipatory breach of contract occurs when a party to a contract disables himself from performing or refuses to perform the contract before the time or the date of the performance is due. Anticipatory breach of contract may take place in two ways. First, express anticipatory breach by written or spoken words. Second, implied anticipatory breach of contract. Effect of anticipatory breach of contract. First, the aggrieved party may immediately put an end to the contract and treat it as discharged and can bring an action. Second, the aggrieved party may treat the contract as alive and wait for the performance till the agreed date or time arrives. If it does so, following shall be kept in mind. First, the contract will remain operative for both the parties. Second, the contract will stand discharged in any case of supervening impossibility. Remedies for the breach of contract. First, suit for rescission of the contract. Second, suit for damages. Damages are of 6 types. A. Natural or ordinary damages. B. Spatial damages. C. No compensation for any remote and indirect loss. D. Exemplary damages. Court may award exemplary damages in case of significant contracts as first, breach of a contract to marry a person. Second, Wrongful dishonor of a check by a banker of his client. E. Nominal damages. F. Liquidated damages and penalties. When it is stipulated in a contract that party breaching the contract will pay specific amount. In case of breach, it is known as liquidated damages. When the amount stipulated in a contract at the time of its formation is highly disproportionate to the likely damages in the event of its breach, it is known as penalty. Third, suit for quantum merit. That means as much as earned. Fourth, suit for specific performance. Fifth, suit for injunction.